Namaste and a very warm welcome from Team The Indian Lawyer to this new episode of the Indian Lawyer Legal Tips. I am Sushila Ram Varma, Chief Consultant at the firm. Very often in my years of practice, I have seen people come to us really worried when they are summoned by the police or they have received a notice or they are told that they are made a part of a criminal case. Keeping this in mind, we thought, let us make a simple video on what happens when there is a police complaint. Now, let us understand what are the types of offences in India. Under the criminal laws, they are cognizable offences or non-cognizable offences. Cognizable offences are those offences which are heinous in nature and in which the police can arrest or lodge an FIR or even investigate without the permission of the magistrate. These are cases where there is robbery or there is a rape or murder. Then there are non-cognizable cases in which the police has to get a warrant issued from the magistrate before they can go and proceed in the matter. These would be lesser crimes. Now, coming to another very important aspect, what offences are bailable and what are non-bailable. The offences which are bailable or non-bailable are mentioned in the criminal laws, but the process of bail can be a little different. In a bailable offence, a person can approach the police station or the police and inform them that they would like to take bail, and after they give the bail amount and the sureties, they are released. But in a non-bailable offence, the matter goes to the court, and the court, only upon being satisfied that the offence that is made out is such that bail can be granted, will give the bail. Now let us understand the step-by-step process that goes into an FIR. If it's a cognizable offence, the police is compelled to file an FIR. If it's a non-cognizable offence, the police looks at the complaint, and if it is satisfied, then it lodges an FIR. Once the FIR is lodged, the complainant is examined by the police and his statement is recorded. Upon recording of the statement, the police starts the investigation. Once the investigation makes a headway, the police will file a charge sheet in the case. This charge sheet will be filed before the concerned magistrate. Upon filing of the charge sheet, the police is also compelled to file all the evidence that they have collected. Once the magistrate is satisfied that the charge sheet and the evidence is before its court, the magistrate will decide the matter as per the law. A question that often pops up in the mind of clients when they are consulting a lawyer is, what is the remedy if the police is not acting against my complaint? Now, in a non-cognizable offence, there are times when the police is showing inaction. In such a case, the option left to the complainant is to file a private complaint under Section 190 read with Section 200 of the CRPC before the concerned magistrate. Now, what happens if the police refuse to register the FIR in a cognizable offence? The complainant should approach the concerned superintendent of police in that particular area and should bring him up to date on why the police is showing inaction when there is a cognizable offence and the complaint is not being taken seriously. Thereafter, the SP will either take up the matter himself or he will allot the matter to some other policeman and the investigation will begin. If the police still continues with inaction, the complainant has the option of approaching a magistrate and filing a complaint under 156(3), asking the magistrate to ask the police to investigate. In some cases, a complaint can also be made in the Home Ministry or the concerned Anti-Corruption Bureau, etc., if the complainant feels that the matter should come up before such a ministry or body. Now, let us examine a very important case in criminal law pertaining to police inaction. This is a case that has been decided by the Supreme Court of India in 2017. It is titled as Lalita Kumari versus Government of UP and others. In this particular case, the father of a minor, Lalita Kumari, filed a writ petition for habeas corpus against the respondents looking for his minor daughter. The police did not take any action, and thereafter he approached the superintendent of police concerned with the matter. Sadly, that the SP also did not bother to take any action. Frustrated with the entire turn of events, he finally approached the Supreme Court seeking some relief. In this judgment, the Supreme Court wrote that the Supreme Court directed that in case it's a cognizable offence, FIR is mandatory under Section 154 of the CRPC, and there is no requirement for a preliminary inquiry before the FIR is lodged. Another very important aspect that was considered by this court was that if there is a complaint in a non-cognizable matter, then the police has a duty to investigate or make an inquiry into what the complainant is saying and thereafter lodge an FIR. This would be typically in cases that are there in matrimonial matters or family disputes. The criminal law in India mandates that a police must register an FIR if there is a cognizable offence. There are many instances when, despite a cognizable offence being made out, the police refuses to take action. This could be because they have taken bribe or there is some political pressure on them, etc. In such a case, the complainant can move the court and complain about the inefficiency of the police and let the concerned court pass the directions that it has to pass. Criminal law and procedures in India are very lengthy and at the same time a little complex. So it is very difficult for us to give you more information in a short episode like legal tips. In the event that you have to lodge an FIR for either a cognizable or a non-cognizable offence and you are not sure as to what should be done, I would strictly advise that you approach a lawyer, discuss the matter with him or her, and then lodge the FIR. Dear viewers, a very big thank you to all of you for having given us so much of support and for viewing our videos regularly. The subscriber base has also increased very quickly. I would, however, like to make a small mention. We at the Indian Law and Allied Services have started this program, the Indian Lawyer Legal Tips, as our corporate social responsibility to society, and we therefore aim that these videos should reach the masses as much as they can. We therefore humbly request you to please like, share and subscribe so that more and more people can actually view these videos and get some help from our efforts. Thank you, dear viewers, for viewing our video and helping us to grow. We shall meet you very soon with the next video next week. And thank you and namaste.